When it comes to dividing a business in a divorce, it's really going to depend upon how that business is structured. So if you have a spouse that's working in a business and they own the business, we're really going to have to look at the type of business. How intricately involved is this person in there? If they are simply a shareholder or partner, their portion may be divisible in a divorce. If they are intricately involved, such as a sole proprietor, or they're the ones that are really doing the work, it may be difficult to divide up the business. So if you have a divorce or a potential divorce and you are the business owner or the spouse of the business owner, it's really important that you get with an attorney quickly in a case before you even get started. Somebody that knows what they're doing when it comes to businesses. Somebody that understands the difference between an LLC, a sole proprietor, a C Corp, an S Corp. These are things that make a difference with how you're dividing your assets, which might be something you're entitled to. And if you do it wrong, it's really hard to undo it later. When it comes to valuing a business in a divorce, typically you're going to have to do it in a few different ways. First of all, the easiest way to do it is to come up with an agreement. Now, this is not always easily done. A lot of times, depending upon what side you're on, you're going to want to project it at a higher or lower value. So there are people that can help you with this process. There are people that actually value these businesses and they can put together a professional business valuation. Ultimately, what you're looking for is probably a fair market analysis. A fair market analysis typically looks at and says, if we had a good faith buyer, a good faith seller, what would this business go for on an open market? If you can come up with that value, that's often going to be a good set to say, this is what this thing is worth. But there are a lot more factors that go into it. In other words, that might be what it's worth now, but is there any information that might change that in the future, good or bad? So depending upon what side you're on, it's really important that you get your arguments right, your facts straight, so you can present that to the court and ultimately get a better valuation for your business. When it comes to things such as stock options, bonuses, commissions, that can really change the calculations of support and asset distribution. So let's talk first about things such as stock options. Stock options are essentially an asset that might happen in the future. In other words, usually there's some sort of vesting tool that takes place. So when it comes to stock options, it's really fact dependent. What you have to figure out is, how are these stock options awarded? When do they vest? And when does the asset actually become something that the employee has? So for example, sometimes people might get stock options that don't vest until a certain period of time. In that situation, the alternate payee or the spouse can simply ask for whatever the recipient spouse would get. So in other words, let's say that a stock option was awarded but doesn't vest for a period of time. The other spouse can request to have a portion of that stock option when and if it becomes available. In other words, if it comes available, they get a portion. If it turns out to be zero, or they never vest or they never get those options, they get zero. It's really fact specific. It's really important that you understand how they work in that individual situation so you can ultimately create a plan that makes sense for you. Now, when it comes to things like bonuses, commissions, or irregular income, that can really impact your child support and your maintenance calculations. You see, in a situation like this, such as a salesperson where they have irregular income or bonuses or commissions, what we're really trying to do is we're projecting forward. We're trying to figure out what's reasonably foreseeable. In a sales job, people might say, well, I'm bonuses or I'm commission, I never know what I'm going to get. But the reality is we usually have some sort of range, a certain low and a certain high of what we can expect. So when you have a situation like that, when you have irregular income like that, what you want to do is set a base amount, a base number that we can count on. Use that number for purposes of your child support and your maintenance. Now, depending upon what that number may be, you then may need to consider doing something called a true-up, which is a device or it's a situation where you basically say, here's the baseline that we're going to be, and then we're going to true up that number. So in other words, let's say we set an income at $100,000, but the person ended up making $150,000. We would then come back at a certain period of time and say, we now need to calculate child support or maintenance based upon $150,000 because we calculated based upon $100,000. And then what we would do is give them credit for what's already been paid and figure out what that difference would be and set up a payment plan on that money. A true up is something that can be dangerous. If you do it the wrong way, it can cause terrible, terrible post-decree litigation. So it's really important that you have an attorney that knows how to draft these things, that knows how to put the right language in there, because unfortunately, if you do it wrong, you're going to end up spending many, many years in court fighting over things that should have been done the right way the first time. Your spouse's future earning capacity can and does impact how your assets are divided. So when a court is looking at how to divide up the marital property, one of the things they're going to look at is say, well, who has the ability to earn more money? Who has the ability to continue towards that standard of living compared to the other? If one person significantly has the earning capacity higher than the other one, a court's going to consider that and may award more property to the person with a lower earning capacity based upon that factor. QILDROs are important in an Illinois divorce. If you or your spouse works for an Illinois government entity, such as a police department, fire department, or any other government entity, chances are they have access to a pension and an Illinois retirement plan. In this circumstance, they do not use QUILDROs. They use a thing called QILDROs. So it's QILDRO. QILDRO stands for Qualified Illinois Domestic Relations Order. What this means is you have to follow the rules in particular for that pension plan. It's really important that you understand a few things that are really important and unique to QILDROs. That is, you can only get your portion of the retirement as the alternate payee, in other words, the spouse, when the participant retires. You can only get your portion so long as they're receiving theirs. Typically, there are no opportunities to get that early and no opportunities to keep it after the participant dies. When it comes to QILDROs, these are not something that you want to do with half information. You want to make sure you understand them. When you retire is going to make an impact on how this gets paid out. When your spouse is retiring, it's going to impact things. They are a unique animal, and it's important that you understand exactly how they work in your situation. So it's important you get the right information so you can make the best decision for you.